Good morning to all. Welcome to the appellate court. We're going to hear two cases this morning. The first case we're going to hear is Ian Wright versus the Commissioner, DZURENDA, AC number 43888. The first order of business is to have everybody introduce themselves, starting with the judges, and then Mr. Wright, and then finally Mr. Davis. I'm Judge Prescott.
I am Judge Suarez.
And I'm Judge Vertifay.
Ian Wright, the appellant.
Okay.
Tom Davis for the appellee.
All right. We are conducting this hearing on the Microsoft Teams platform. It's a virtual hearing. Mr. Wright is appearing from the Correctional Institute, where he is now currently residing. We are also live streaming this hearing on the Judicial Branch's YouTube channel. I don't think it's implicated in this case, but if there were to be any information that's protected, the confidentiality of which is protected by statute, please be careful not to disclose it. Again, I don't think that applies to this case. Each side has 20 minutes for argument. Mr. Wright, if you want to preserve a portion of that 20 minutes to respond to what Attorney Davis says, what we call rebuttal argument, you can let me know when you begin your argument. When you have about 2 minutes remaining in any portion of your argument, I'm going to hold up this fancy sign just to give you a warning that it's almost time to wrap up. You should have received instructions from in an email about the manner in which we're conducting this hearing. Please let me know if you have any questions about that. Please keep your microphones muted while you're not speaking. And that will help reduce feedback and improve the quality of this virtual hearing. Mr. Wright, do you have any questions, or Attorney Davis, do you have any questions?
No, Your Honor.
Your Honor, I have one question. Since I can't actually see you, I'm not quite sure how I'll know if I'm about to be asked a question and how we should manage that.
We'll have to kind of barge in and get your attention. We'll do the best we can.
Very good.
Okay. All right, Mr. Wright, you're all set. Would you like to reserve any of your time for rebuttal?
5 minutes, please.
All right, you got it. Go ahead.
Okay, good morning to the court and AG Davis. As you know, my name is Ian Wright. I'm the appellant. The purpose of this argument is to further demonstrate to the court that the trial court erred in granting the appellee defendant motion to dismiss my retaliation claim against her. My retaliation claim against her was properly exhausted, and furthermore, she waived her affirmative defense of exhaustion of administrative remedies by failing to raise the defense in her pleadings prior to filing the motion to dismiss. The defendant seemed to suggest in her brief at page 10 that I recognize my access to typewriter claim is a different species. Then that's my retaliation claim. That is the reason why I pled them separately. That assertion is counterfactual, and I pled those claims separately because I knew both claims were properly exhausted. Both claims contain virtually identical set of facts, specifically that the defendant denied me access to a typewriter in retaliation because I filed a grievance against her. The defendant has conceded that my access to the court claim was properly exhausted, but now argued that my retaliation claim against her which contains similar allegation was not exhausted simply because the grievance omitted the word retaliation. In support of her assertion, the defendant relies on Lawrence versus Gord, cited in her brief, which was decided in 2002. However, in Johnson versus Tessman, decided in 2004, cited in my brief, the court held that grievances filed by prisoners need not lay out facts, articulate legal theories, or demand particular relief, all he need to do is object intelligibly to assert the shortcoming, which in this case is the denial of adequate access to a typewriter. In accordance with the Department of Corrections AD 9.6, my grievance filed against her commenced on or around April 2014, when I sought informal resolution, not on June 10 as a defendant claimed. I would argue that the holding in Testament is the controlling authority as to whether I properly exhausted my retaliation claim against her.
Can I interrupt for a minute? Justice Verdefe, would you mind muting your microphone if you're not asking?
I don't, oh, me?
No, Justice
Okay.
Verdefe.
I'm gonna click now. Hopefully it's mute.
Okay.
There you go. Perfect. Thank you.
I can't hear you now, Your Honor.
Go ahead, Mr. Wright.
Go ahead.
Yep.
Okay. So in regards to my second claim again, with regards to this appeal, the defendant waiver or affirmative defense of exhaustion of administrative remedy. I would argue that she did this by failing to effectively plead that defense prior to filing the motion to dismiss. The defendant filed two motions to dismiss, one on March 24, 2015, then another one on October 16, 2018, both of which was denied and granted in part by the court. In those motions, she failed to raise the motion of the defense of exhaustion, failure to exhaust. Then on April 15, 2019, she filed a motion to summary judgment, which was denied by the court. In that motion, she also failed to raise that defense. I would argue that the summary judgment would be the appropriate vehicle to raise that affirmative defense, and she did not. On October 28, the defendant filed an answer special defense. Here it should be noted that the pleading was entitled amended answer. Clearly, this indicates that she filed an answer and special defense prior to the amended to amend it. However, I was never provided a copy of that amended pleading. The defendant filed a trial manager report, a pre-trial memorandum on October 16, 2018. In both pleadings, she did not indicate that she was or would raise the affirmative defense of failure to exhaust administrative remedy. On December, at the 11th hour on December 12, 2019, the defendant filed a motion, the motion to dismiss and a request for leave to amend the answer, to which I received a copy of the pleadings on December 13th, the day when evidence was scheduled to begin for trial. I would argue that she realized that the filing or prior answer, she waived her exhaustive defense, so she tried to remedy the omission. She filed the December 12th leave to amend. A hearing was conducted that same day by the court, to which I could not offer an effective rebuttal evidence because I received a copy of the pleading just minutes before the hearing. I was unprepared, and the motion to dismiss amounted not more than a prejudicial surprise. First and foremost, the exhaustion to exhaust administrative remedy is an affirmative defense, which can be waived. The defendant failed to raise the defense in her prior motions, and filed a motion, a special defense prior to filing the motions. The defendant failed to follow the chronology established by Practice Book Section 10.6. This is generally deemed a waiver of right to file listed pleadings in accordance with Practice Book 10/7, and failed to seek prior approval from the court to file an answer or special defense. By failing by filing her answer special defense prior to her motion to defense, failing to move the court for leave to file that motion out of order, defendant effectively waived the special defense of failure to exhaust, and the court erred in granting her motion in that respect. Failure to follow the chronology established by practice book section 10.6 is generally deemed a waiver of right to file a listed pleading under section 10/7. If the defendant had wished to file out of order, she should have sought prior approval from the court, which she did not. The defendant had ample time in which to seek approval to file an amended answer, as the case was pending before the court for 5 years. She filed a second amended answer on December 12, as stated before, the same day the motion to dismiss for failure to exhaust was filed, to which like I said, I received a copy on December 13, the day evidence was scheduled to be presented to the court after the jury was picked and we were ready to go to trial. I wasn't given any additional time or a continuance to properly effectively present a rebuttal or opposition to the defendant's amended answer or a motion to dismiss, which left me at a disadvantage. I would now yield the rest of my time to any questions.
All right, I don't see that judges have any questions at this point. So you'll have some remaining time for rebuttal. Attorney Davis.
Okay.
Thank you, Judge. Judge Brazel-Massaro's decision must be affirmed because the appellant didn't exhaust the specific administrative remedy that existed and was available for a retaliation claim. Now, that's really the dispute here isn't about the underlying facts of what the documents and the exhaustion attempts and so forth are. The dispute is whether or not a non-grievance document, what's called a CN 9601, an inmate request form, filed in June 10 of 2014, could be considered part of an exhaustion of a grievance filed a month before relating to an informal resolution attempt a month before that. And the reason it cannot, the basic reason, is that the retaliation by the plaintiff's own account did not occur until after the grievance process underlying this matter, begun in April and followed with the formal grievance level 1 in May, was commenced. So the suggestion that what was Exhibit H, FGH, yes, at the evidentiary hearing, which was the June 10 informal resolution attempt that did mention retaliation, could somehow constitute proper exhaustion on the prior pending event isn't possible. The retaliation hadn't yet occurred when the alleged retaliation hadn't yet occurred when the prior process of grievance was commenced and was underway. Moreover, the plaintiff never mentioned retaliation either in his prior informal resolution attempt from April of 2014 or in his grievance in May of 2014 or in his appeal of the denial of his grievance. No reference whatsoever to anything to do with retaliation. And because retaliation is a separate species of claim, and the Second Circuit has held clearly that retaliation claims must be individually exhausted, he simply did not exhaust the administrative remedy process. And the judge made findings in the transcript. The court will find her findings that Mr. Wright was very familiar with the administrative remedy process, that he handled himself and was aware of that process and litigation rules in a manner that was superior to many self-represented lawyers that she'd actually had in front of her. So I don't think there's a serious question about the underlying facts. The only question here is whether or not that informal document, inmate request form of June 10, can be bootstrapped backward in time, claiming to make a grievance that wasn't about retaliation, to become a grievance about retaliation, when the people handling the grievance and the appeal of the grievance had no notice of anything about retaliation. And that simply would violate everything that the case law says about the exhaustion requirement of the Prison Litigation Reform Act. That's I think the most important point. The Supreme Court has made it very clear, and the Second Circuit has made it clear, that the Prison Litigation Reform Act requires and it mandates this exhaustion, and it simply wasn't done. And the case law is also clear from Lawrence versus Gord that you have to do it with respect to individual retaliation claims. That's very important because that's what we're dealing with here. And that was the result of the Supreme Court's decision in Gord versus Lawrence reversing the Second Circuit that had previously held you didn't have to do that. So it's very clear at the highest level that we know the proper interpretation of PLRA is that individualized retaliatory conduct claims must be exhausted specifically. The denial of access court claim about a typewriter in count 2 of the complaint against Hakens, the counselor, was exhausted. That's not disputed. That particular count was dismissed in previous action in the case because the plaintiff hadn't established sufficient injury to have standing. That's a completely different issue. And the fact that it was access to typewriter is completely different than the elements and the reality of a cause of action for retaliation. And that's very important because the entire purpose of the PLRA, according to the Supreme Court decisions, is to reduce the number of non-meritorious and even frivolous claims that are flooding the courts. So it would be no surprise, for instance, that the same result would happen with inmate request forms and grievances, that the majority of them are probably not meritorious. But intervening that step allows the prison authorities to address what might be meritorious and to address the entire claim. With respect to this grievance, nobody at DOC had been alerted that the grievance from May, Exhibit G in the evidentiary hearing, would have contained any claim of retaliation. If retaliation claims could be exhausted in that manner, it would mean that any time an inmate files a grievance and that grievance is denied, or it could even be when the grievance is granted or upheld, anytime he files a grievance, he can then go ahead and file suit after exhaust that particular grievance and tack on a retaliation claim without ever mentioned it to anybody, because he sent some note to somebody after the fact saying, oh, by the way, I'm being retaliated against. And it would just flood the court retaliatory claims. So I think that would frustrate the entire purpose, as Woodford pointed out, of the PLRA. With respect to the waiver argument, I think Mr. Wright has argued that an amended answer was filed on October 28, 2019. That's incorrect. The first time an answer was filed in this case was October 28, 2019. There had been no previous answer filed. I came into this case in October and took over to handle a motion for summary judgment argument. I filed that motion on the 28th, the same day that the motion for summary judgment was argued. Nothing in that argument, nothing in that motion for summary judgment dealt with the issue of exhaustion of administrative remedies. I raised it in the answer. It's the first answer in the case, and 44 days later, filed a motion for an evidentiary hearing. I cannot imagine that a 44-day period can constitute a waiver of a right. Certainly, it can't constitute a known waiver or a known relinquishment of a particular right, which I think would be the standard for a waiver. There was an amended answer, that's true. That was filed on December 12th, but that was merely, as the transcript overwhelmingly points out, to correct spelling errors and typographical grammatical errors in the answer filed on October 28th. There was no substantive change whatsoever.
Attorney
Davis,
let me interrupt for a minute. I see the amended answer at page A89 of your appendix. Is the previous answer in your appendix?
It should be. Let me take a quick look. I have a table of content. I'm sorry, I have my brief open instead of the appendix.
Is it the,
December, whenever you file an amended answer, you would file a copy of what you're amending, both a red line copy, underline copy. I'm just trying to see if both were.
So I see an answer at A71 of your appendix.
A71. That's the original answer, A71,
All right.
October 28th. The amended answer should be at A86.
89, it looks like on mine. Okay. All right. That's helpful. Thank you.
Okay. It's true that a exhaustive administrative remedy is not subject matter jurisdiction. I never raised it as subject matter jurisdiction. Nothing from me ever suggested it was subject matter jurisdiction. It is a gatekeeper function to a court because the PLRA requires pre-filing and exhaustion. Now, it would not be appropriate, in my mind, to be a straightforward motion to dismiss, which are traditionally limited to the four corners of the complaint and raise the issue of jurisdiction, because it doesn't actually raise the issue of jurisdiction, but it does raise a special federal congressional mandate with respect to actions brought pursuant to 42 U.S.C. 1983 or pursuant to any other federal law. So the court has to conduct some kind of gatekeeping function, and in that process, the court is not limited to undisputed facts. The court can make judgments of credibility. It can resolve disputed issues of fact, and it can rule on whether or not that's been exhausted. In such a situation, an appellate reviewing court would look at the application of fact to law de novo, but with respect to findings of fact, the court would be faced with a clearly erroneous standard because the judge is entitled to make findings of fact. And in this particular case, the judge made findings that this particular plaintiff was well acquainted with the process, knew what had to be done, and didn't do it. So I think those are very important points. Finally, that Mr. Wright points to the Second Circuit's opinion, and I believe it was Johnson versus Testament. That's an important case, but it's an old case. It was handed down the same day as the Second Circuit's opinion, and Hemphill, which had created judicially structured exceptions to exhaustion. The Supreme Court subsequently overruled that kind of judicial created exceptions and said they're limited to the textual language of the statute. If the remedy is available, it's available. And there are some exceptions to availability that, because they relate to the word available, none of them are implicated in this case. So, and in that particular case, it's true, Testament, Johnson versus Testament, the Second Circuit said you could waive this particular defense. I agree, you could waive this defense. It wasn't waived in this case, however. In that case, it was waived because counsel told the court it wasn't pursuing it. And the court commented counsel seemed to be trying to say they weren't going to pursue that at the trial court level, but would pull it out on appeal, and that they simply could not do. And of course, that makes sense as well. But that's not what happened here. It was raised in a manner that did not violate the order of pleadings. The answer was filed. It's a long time before the answer was filed. I can't tell you why it wasn't filed sooner. But when I came in the case, I filed the answer. Shortly thereafter, a little over a month after I received the plaintiff's trial exhibits and could examine those exhibits and satisfy myself that he had no other documents in there other than the same documents I was proposing. And by the way, in his trial exhibits, I point out in my brief, and they're in the appendix, the list of exhibits, plaintiff was gearing up to establish exhaustion. He was going in with Administrative Remedy 9.6 as an exhibit, and the grievance process regarding access to court and strip search. And was going to go in with the June Exhibit H, my Exhibit H, with respect to mentioning retaliation on an informal. So none of this came as a surprise to anybody that exhaustion of administrative remedy was an issue that had to be addressed. It came out in the judge's opinion on the motion for summary judgment, where she addressed it about a month before the trial was to commence, before the evidentiary hearing. But it wasn't argued at summary judgment. It wasn't an issue before the court on summary judgment. But in any event, what she said was in the memorandum of decision, it was an issue that was a disputed fact and would have to be resolved later on in the case. So I don't think there's waiver. I think the failure to exhaust is clear, and the decision dismissing should be upheld.
All right, thank you, Attorney Davis. Mr. Wright, you have some rebuttal time.
Yes, so AG Davis keep pointing out to the court that the court commended that, saying that I know the rule. What he failed to tell the court that according to Department Correction policy, you can't file a successive petition, which essentially, if I had filed another grievance, just put in retaliation in it, it would have been a successive petition. As he stated that I did file an informal resolution, but that was it. I couldn't file a grievance after that, because if I had filed a grievance to follow up on that, just put in retaliation, it would have been deemed a successive petition. And that's so that's why Testament would be the controlling case in this case, because it states that I don't need to lay out facts, articulate legal theories, or demand a particular relief. Testament, or his case that he cited, Gord, Testament is a later case that was decided after Gord. And as it relates to its claim in regards to my affirmative defense, he did waive it. If the defendant filed 2 motions to dismiss, failed to raise the defense in a summary judgment, and then at the 11th hour, 1 day before trial, filed a motion to dismiss. If that's not a waiver, I don't know what is, Your Honor. They had ample time. The case was pending before the court for 5 years. This is a state attorney that has everything at their disposal, and they failed to file the defense or affirmative defense in 5 years. And like I said, failure to exhaust is the affirmative defense that can be waived. And if after 5 years that's not a waiver, I don't know what is a waiver. At 1 day before trial, the day of trial, that's when I received the motion and I had to argue. Wasn't given no additional time to rebut or anything. The jury was actually outside waiting for on start evidence that day. That's the day that he filed it. If that kid is not deemed a waiver, I don't know what else is a waiver. This is they clearly waived their right to file the affirmative defense. Even in the pleading, if you look at the docket sheet, they did file an amended answer on October 28th. Which if you look in my appendix, is entitled amended answer. Then Mr. Davis, he filed his his on later on, but it was I think Attorney Wilson was the attorney then, and he filed an answer on October 28th. That's listed on the docket sheet. And if you look on my appendix in the back, I provide the court with a copy of it, and it's entitled amended answer. Amended to me would mean that an answer was filed prior. Maybe I'm wrong. I never received a copy of it, so I have no idea.
Okay, anything else?
No, that's it, Your Honor.
All right, thank you for participating, both of you, in this hearing. Mr. Wright, I want to commend you for an excellent presentation, particularly for someone who's not a lawyer. We're going to take the matter under advisement, and we will take a recess before our next case. Thank you both.
Thank you, Your Honor.
Thank you, Judge.
All right, Mr. Davis.
Good luck to you, Mr. Wright.